Call the meeting to order. This is meeting number 36 of the Standing Committee on Justice and Human Rights. Today is Monday, October the 5th, 2009. And just a note that today's meeting is being televised. You have before you the agenda for today. We have two matters to deal with. During the first hour, we'll begin a review of the Canadian Human Rights Act, and more particularly Section 13 of that Act. We also have two witnesses appearing on that matter. And just so you know, during the second hour, we'll return to our review of Bill S4, an act to amend the Criminal Code, identity theft and related misconduct, and we have one witness appearing on that bill. And once again, a reminder to everyone in this room, please turn off your Blackberries or put them on vibrate. We want to make sure that there's no disturbances during our meeting. And if you are receiving a call, please take it outside of this room. Thank you for your cooperation in that regard. So back to our review of the Canadian Human Rights Act. To help us with our review, we have with us two witnesses as individuals. We have Mark Steyn and we also have Ezra Levant. So welcome to both of you. And I think you've probably been apprised of the process. Each of you has 10 minutes to present. Then we'll throw the floor open for questions by our committee members. So Mr. Levant, if you would start, you have 10 minutes.
Thank you. I appreciate this invitation very much. And I appreciate the fact that this is a multi-partisan committee, because I believe that freedom of speech, the rule of law, and checks and balances in quasi-judicial tribunals are not the property of any one party or indeed any one ideology. Therefore, anyone who believes in debates and discussions, I believe that freedom of speech is a Canadian value. I'd like to read some prepared remarks. Last month, Section 13 of the Canadian Human Rights Act, the censorship provision, was declared unconstitutional. Athanasios Hadjis, the vice chair of the Canadian Human Rights Tribunal, ruled that section violated the Charter. He said the Canadian Human Rights Commission had become a bully. He called it, quote, aggressive and confrontational. And in March, Edward Lustig, another tribunal member, ruled that the Commission's conduct was, quote, disturbing and disappointing, unquote. He said he would follow Mr. Hadjis's lead on the question of its constitutionality. Mr. Hadjis is the past president of a large multicultural organization in Montreal, and he was appointed to the tribunal by Prime Minister Chrétien. Mr. Lustig was appointed by Prime Minister Harper. So that's the state of affairs today. Conservative and liberal members of the tribunal agree. The Commission is out of control. The tribunal will not enforce this illegal law. They've concluded that the Commission is abusing our human rights, like freedom of speech. So how did things get off the rails? To understand what the Commission does, we have to understand what it doesn't do. It doesn't help minorities. It doesn't help immigrants or gays. In fact, all but two of the Commission's censorship prosecutions in the past decade have been launched by the same one individual, a privileged white male lawyer right here in Ottawa named Richard Warman. He was actually a Commission employee, and he started filing censorship complaints while he worked there. And his co-workers would investigate his complaints. Needless to say, he won them all, and he was awarded tens of thousands of dollars tax-free. When Mr. Warman left the Commission 5 years ago and went to work for the Department of National Defense, he continued to file complaints. Even though he no longer works for the Commission, they still pay his expenses: travel, hotels, parking, meals, even an honorarium. The Commission doesn't pay anyone else in Canada to file complaints. Section 13 really is Richard Warman's personal law. Without him, there would be no prosecutions. That in itself raises questions like conflict of interest and abuse of office and malicious prosecution. But that's not why Mr. Hadjis or Mr. Lustig rejected Section 13. Like I mentioned, they called the Commission disturbing, disappointing, aggressive, and confrontational. I'll give you examples of that conduct now. I think it will shock you. I myself couldn't believe it at first, so I would be happy to provide documentary evidence for what I'm about to say, almost all of which comes from sworn testimony of Commission staff themselves. Here goes. Mr. Warman does something I don't think Canadians expect a government employee to do. For nearly 10 years, he's been a member of a neo-Nazi group called Stormfront. and another neo-Nazi group called Vanguard, and another called the Canadian Heritage Alliance. He actually fills out membership forms, and then he goes online to their websites and writes bigoted, hateful things, like that gays are a, quote, cancer on society, or white police should be loyal to, quote, their race, or that Jews like your colleague, Erwin Kotler, are, quote, scum. Seriously, he did this as a commission employee. He wrote hundreds of bigoted messages like that. And he convinced other commission staff to do the same thing. At least 7 staff have membership privileges in Nazi organizations. Last year, Commission investigator Dean Stacey admitted under oath that he was one of them. And he fingered his 2 assistants, and Sandy Kozak, and Giacomo Vigna, and their manager, John Chamberlain, too. They all have access to neo-Nazi membership accounts. Several years ago, Mr. Warman, Mr. Vigna, and Mr. Stacey sat down at a commission computer together and logged into a neo-Nazi website using their membership. But to cover their tracks, they hacked into a wireless internet account of a private citizen named Nellie Heshmi, so they couldn't be traced back to the commission. Bell Canada's security officer testified to this fact, and the RCMP investigated this hacking for months. The status of the investigation is officially, quote, unsolved, but the commission remains the only suspect. I could go on. I could mention the lack of a written ethics code, that Ms. Kozak at the commission was hired after she was drummed out of a police force for corruption, that the commission illegally borrows material from police evidence lockers without a search warrant, that Mr. Stacey boasts that this kind of behavior doesn't break any rules at the commission because there are no rules to break. And instead of cleaning up this filthy, bigoted mess, the chief of the commission, appointed by the Conservatives, Jennifer Lynch, defends this conduct and attacks anyone who criticizes it. Section 13 was thrown out not just because censorship is un-Canadian, illiberal, and a violation of our charter. It was thrown out because the Commission itself has become a threat to our human rights. And both the Liberal and Conservative tribunal members refuse to let that go on 1 minute longer. I hope this committee will be united in their revulsion to what I've just reported to. I can talk about this in the media or on my blog, and so can Mr. Steyn, but only the people in this room and this building can actually put a stop to it. Thank you. I now look forward to your questions.
Thank you, Mr. Levant. We'll move on to Mr. Steyn. You've got 10 minutes to present.
I want to second what Ezra Levant has said. Something has gone badly wrong in the Canadian state's conception of human rights. Until last month, Section 13 had a 100% conviction rate. Even Saddam Hussein and Kim Jong-il understood that you don't want to make the racket look too obvious. Under Section 13, citizens are subject to lifetime speech bans, not in the Soviet Union, not in Saudi Arabia, but in Canada. Section 13 prosecutes not crimes, but pre-crimes, crimes that have not yet taken place. The phrase pre-crime, by the way, comes from a dystopian science fiction story written by Philip K. Dick in 1956. Half a century later, in one of the oldest, most stable democratic societies on the planet, we're living it. Until Maclean's magazine and I intervened last year, the Section 13 trial of Mark Lemire was due to be held in secret. Secret trials, not in Beijing or Tehran, but here in Ottawa. It is not the job of either Maclean's magazine or myself to demand that in this country trials cannot be held in secret. That is the job of you and your colleagues and this Parliament. Section 13 is at odds with this country's entire legal inheritance, stretching back to Magna Carta. Back then, if you recall, 1215, Human rights meant that the king could be restrained by his subjects. 8 years later, Canada's pseudo-human rights apparatchiks at the Commission have entirely inverted that proposition. And human rights now means that the subjects get restrained by the Crown in the cause of so-called collective rights that can only be regulated by the state.